Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Thank you for joining us for this Synergy webinar on hidden Medicare Advantage liens. Because they are often hidden or unknown, they require some due diligence on your part to make sure that you are shielded from double damages. So my name is Teresa Kenyon. I am the Director of Lien Resolution Services here at Synergy Settlement Services. I am a California and Kentucky licensed attorney. Prior to joining Synergy about 3 years ago, I worked with the Rawlings Company on behalf of those health insurance carriers that are seeking reimbursement. I'm now on the other side, the side that I always should have been on. We call it the bright side. So I've got a team of file handlers, of negotiators, passion fighters that are fighting and battling on these liens, trying to get them reduced or waived by any means possible, digging into the legality of it all, policy language for ERISA plans, and all of that. The team is growing on a regular basis, and we've got over 300 years combined experience on battling liens. Most of the team is from the other side as well, so we've got what we call insider knowledge on how things work with these various companies that we work with on a regular basis. So what kind of liens do we handle? What can you send over to Synergy to handle on your behalf? Health liens, that's definitely what we're dealing with. Medical treatment liens. Sometimes we get asked if we handle child support liens and things like that, but no, we definitely do lien resolution, but it's surrounding medical treatment. So those are going to include ERISA plans and then also non-ERISA plans, which is going to be more private insurance, could be an individual plan, something along those lines. We've got FEBA plans for federal employees, Medicaid, which would also include the MCOs, so that's Medicaid with a traditional state agency, but also the ones that are handled by private insurers. Military liens, which include VA and TRICARE, Medicare, which is traditional Medicare through the BCRC, but then also Medicare Advantage plans, Medicare RX plans, which are handled through private insurers, and then hospital and provider liens. We do that through our medical bill clinic. It's all still under the lien resolution umbrella, but we've got some special ways to attack those liens and debts that are associated with the hospital and providers who have not been paid by health insurance. Today's agenda, we are definitely talking about Medicare Advantage, but we have to start with traditional Medicare, really just how it started and then how it morphed into Medicare Part C plans. Then what comes from that are those Part C or Medicare Advantage liens. Procurement reduction is always something to talk about as it relates to Medicare Advantage because traditional Medicare does it very automatically. Advantage plans, maybe not so much. And that's because there are different recovery vendors that are handling those Medicare Advantage plans. So we're going to talk about those recovery vendors and what their position is. Double damages is a big deal with Medicare liens. Also applies to these Medicare Advantage ones. So it's very important that they don't stay hidden because you don't want the double damages to come out of the woodwork. We'll talk about best practices. How is it that you identify and find these Medicare Advantage plans? Just a couple tips to help you. And then the PAID Act. That's the most recent thing that has come out that might actually help uncover these hidden Medicare Advantage liens, or at least that's the hope. So we will have a little bit of discussion about that as well. So let's talk about Medicare, traditional Medicare. So Medicare is a secondary payer, and that is straight from the Medicare statute. It is cited there kind of in the middle of the page, but basically Medicare may not, will not, shall not pay for a beneficiary's medical expenses when payment has been made or can reasonably be expected to be made under another plan. And so those plans would include a workers' compensation plan, an automobile or liability insurance policy or plan, or under no-fault insurance, including MedPay or PIP or any of that other kind of automobile coverage for medical expenses. It is stated that if responsibility for the medical expenses incurred is in dispute and the other insurance won't pay immediately, then the provider can bill Medicare, and Medicare will pay conditionally, subject to the later recovery once the settlement actually occurs, if the settlement actually occurs. And this is where the whole idea of conditional payments comes from. So traditional Medicare is parts A and B. So there are many parts of Medicare, but A and B is the hospital insurance and the medical insurance that is through the government. Part C is the Medicare Advantage plans. These are the ones that are through private insurance companies, but provide the same benefits as Part A and B, and maybe a little bit more as well. And we'll talk about that here shortly. Part D is the prescription add-on that you would add on to a Part A or B plan. In 2022, as far as I could tell, 42% of all Medicare beneficiaries, which is 26 million people out of 68 million Medicare beneficiaries, are in Medicare Advantage plans. And this has gradually, steadily increased over time since the early 2000s. And I've got just a chart there that kind of shows how that has increased. And it's if you watch any bit of daytime TV, you would probably see a handful of Medicare Advantage commercials trying to entice the daytime viewing public to add one of these type of plans instead of using their traditional Medicare. A little bit of facts about Medicare Advantage plans, these Part C plans. It was President Clinton that signed it into law in 1997. It was considered the Medicare Plus Choice policy. The Medicare Modernization Act of 2003 changed the name to Medicare Advantage. They're not private insurance plans, even though they are administered by private insurance companies. They are still funded from the same trust funds that pay for and support traditional Medicare. So these Part C plans, they include all of the Part A and B coverage plus more. And like I mentioned before, those commercials might give somebody a free blanket. Sometimes it gets pretty ridiculous, but sometimes it includes dental or vision or other kind of coverages that otherwise a beneficiary would have to pay extra for. So it's all inclusive in the Part C plan if that's the type of coverage they choose. So the Medicare Advantage plans are governed by the Medicare Act, just like the traditional Medicare coverage. They've got the same rights and responsibilities, and the big key for any of these Medicare plans is that there is double damages that can be awarded if they are not reimbursed from these settlements. So this is why it's really important to make sure that you are capturing these plans and not letting them be hidden and come out of the woodwork later. We will talk a little bit later about how to locate these hidden liens, but this just gives some insight on the types of private insurance carriers that are administering these Medicare Advantage plans. So this can help give you some of that insight on where to look to try to locate them. So United Healthcare and Humana combined cover 45% of all of the Medicare Advantage beneficiaries. Blue Cross Blue Shield, which includes Anthem Blue Cross plans, is another 14%. And then there's 4 other companies. So CVS Health has their own coverage. Kaiser Permanente, Centene, and Cigna are the other 23%. So those are definitely the biggest insurance carriers that are providing this type of Medicare Advantage plan. So certainly when you are talking talking to one of your clients who is a Medicare beneficiary and trying to get to the bottom of whether there might be an Advantage plan, you can maybe ask them if they have a United Health plan, a Humana Health plan, a Blue Cross Blue Shield Health plan, and you'll be hitting the majority. So that's certainly a good place to start. So let's specifically talk about Medicare Advantage liens. So we're going to switch away from just talking about Medicare Advantage in general to the actual liens that might be placed on a settlement. Because if a Medicare Advantage plan pays, it most likely is going to want to reimburse, and it certainly has a right to be reimbursed in these situations. Medicare Advantage plans use the Medicare Secondary Payer Statute as the basis for their claim to reimbursement, and a section of it there is cited. And as such, just like traditional Medicare, these Medicare Advantage plans should be applying a procurement cost reduction. So if their lien is $10,000, their conditional payment is $10,000, and your attorney's fees and costs are 40%, then the most that they should be getting is $6,000. That is what Medicare would do, and that is what a Medicare Advantage plan should also do. But we often find that that's not the case because they're trying to create a lot of their own rules and laws and making certain interpretations in some gray areas, perhaps creating some ambiguity. So we will talk about that here on the next slide. So why is that? Why is it that a Medicare Advantage plan that has the same rights and responsibilities as traditional Medicare wouldn't apply the same parts of the statute, of the Medicare statute? And the big reason is because there's subrogation vendors that are involved with these. We mentioned earlier about United and Humana and Blue Cross Blue Shield and all the various health insurance carriers that are involved. And those health insurance carriers use subrogation vendors like Optum, Equian, Rawlings, Conduent to collect in these kind of situations. Now they do this for ERISA plans, for Medicaid HMO plans, for FEBA plans, and you will see that they are also doing Medicare Advantage plans. They could also be doing Medicare supplement plans. So it's really important when you are digging in on these to find out if it is a supplement or an advantage, because the law is different. A supplement plan is not as strong and doesn't get the benefit of the Medicare statute. It is instead treated like a fully insured plan in that particular state, whatever state it is that that you are from. So let's talk about these recovery players, as I call them. So these big companies that do this on the regular for all of these different types of health plans, they are highly trained, but they're highly trained with very narrow arguments. Some of their arguments as it relates to Medicare Advantage is that they have special rights. Even though they can collect like Medicare, they don't have to do what Medicare does. And we'll talk about that here in a little bit. But you will often get form letters from these employees at these companies. You'll see the same letter over and over again. If it's a Medicare Advantage plan, you'll just get that standard notice letter. You might make some specific arguments and again get a standard response back. Now, the people that you're talking to have a limited authority to actually reduce the lien. They might be able to actually reduce for procurement cost reduction, but they're not going to try to do that on their first round because many attorneys will buy these arguments that they're putting out there and pay them in full for a Medicare Advantage plan because they produce policy language that says that they don't have to reduce for the procurement cost that's required under the Medicare statute. So they will certainly try to do just that and not reduce for procurement cost. It also makes it easier for them to not have to go get approval if they are able to get an attorney to pay the full amount or with very minimal reduction. Sometimes they'll offer some reduction, but not the true procurement cost, and they'll have their reasons for doing so. Now, one thing that's important to know about the people who work at these companies is that they are mostly, and each company is different, but they are mostly very incentivized by the bonus that they receive from the check that you send them. So when they receive a check, they often get a percentage of that check, or they will get credit for it as a check, as a unit that they have recovered on, and then bonus then comes from that. So very motivated to collect, whether it's proper or not, unfortunately, in many situations. So they're also incentivized by reprimand. So some of these are very tight ships by way of quality and making sure that the boxes are checked. Many people are just going through the motions and getting through as many of these files as they can on a daily basis. They could have 500 files at any given time. They could have 1,500 files at any time. But it definitely depends on the company, and it depends on how they're run. But they're often scared of getting in trouble for not doing what the company tells them to do. So just something to keep in mind when you are having those conversations with the file handler on your particular Medicare Advantage lien. Now, this is a snippet, of an example of a letter that came from the Rawlings Company on a Medicare Advantage plan. It was a $34,000 Medicare Advantage lien. This particular case had a large settlement, and because of that, it made the file handler think that they didn't have to reduce as much as they should reduce. And so this is where that incentivized by bonus sets in. With a $1.7 million settlement, they thought that they might try to squeeze a little bit more out here. So they offered $29,000, which is a 15% reduction. Their basis for this, their policy language, and we will take a look at that here in a minute. Now, I had mentioned on a previous slide about the recovery players is that they have narrow arguments that they have been trained on and that they use form letters. And on some level, that is by design. So this here is kind of putting forward the Rawlings position, but this was actually an email from the file handler. They have kind of tightened up their ability to do that. It's definitely not something that they want their file handlers to be doing on a regular basis. They would rather them send the form letter that has been approved as far as the writing of it. But this has some humor in it, not really intentional, but nonetheless it is. So I'm just going to go ahead and read it. So this is in response to requesting a procurement cost reduction as is required under the Medicare statute. So this particular representative says, I have provided you with a copy of the plan language. The contracted language that CMS has approved that your client signed up for that directly addresses the recovery and reimbursement rights. The plan language clearly points out the plan's right of recovery that states we do not have to reduce for cost and fees. I would argue to please present your legal support that the health plan's recovery rights are governed by the Medicare statute and not by the language that was presented to your office and was approved by CMS. As with all health plans, the language is a contract that details the rights the plan has for recovery. In an effort to save everyone time and money, I would be willing to take an offer of $29,000 to my client to get the lien resolved before we start down the path headed for litigation. Please also note to your client that when this gets litigated, we will seek our full attorney fees as well. So I'm pretty sure if Rawlings legal, the head of Rawlings, knew that this was being sent out in email as their position, they wouldn't be happy about it, because this whole argument about the policy language isn't something they want in writing. You're not going to really be seeing this in a form letter because the higher ups at Rawlings know that it's not proper. But the people that are handling the files have been trained that this is what the law is, and they believe it wholeheartedly. So in this particular situation, they want us to prove or to provide our legal support as to why this Medicare Advantage plan is governed by the Medicare statute, which is the comical part. Lots of other little pieces of comedy in there as well, but that is the file handler's position. So let's take a look at the policy language that they are referencing. Now here's two snippets of this policy language that this Rawlings representative was pointing out. So the first paragraph here is a very clear reference to the Medicare statute. We have the right and responsibility to collect for covered Medicare services for which Medicare is not the primary payer. According to CMS regulations, the Aetna Medicare plan, as a Medicare Advantage organization, will exercise the same rights of recovery that the Secretary exercises under CMS regulations in subparts B through D, and the rules established in this section supersede any state laws. Clearly referencing that it's subject to the Medicare statute, points to specific sections. I think they skipped this part. This is certainly not what is trained into them. So then the next paragraph is an example also from the same policy, but this is the conflicting part, and this is the part that they end up really focusing in on. So this is just more or less standard health insurance contract language, but this does reference the MA plan, so the Medicare Advantage plan. So it states that by accepting benefits from your Medicare Advantage plan, you acknowledge that the plan's recovery rights are a first priority claim and are to be paid to the plan before any other claim for your damages. The plan's entitled to full reimbursement on a first dollar basis from any payments, even if such payment to the plan will result in a recovery to you which is insufficient to make you whole or compensate you in part or in whole for the damages you sustained. Your Medicare Advantage plan is not required to participate in or pay court costs or attorney's fees to any attorney hired by you to pursue your damage claims. That is what they are trained to look for in these policies, and that is what the email was arguing, was that the policy language says that they don't have to reduce for procurement cost. Well, the issue is there's no support for this. So sure, this is in the policy language, but where is their legal support that the contract is allowed to make up something else as the basis for their recovery? And as I've indicated here, this is standard health insurance contract language. It talks about first priority, it talks about full reimbursement, it talks about made whole, and attorney fees. This is something you would find in any standard ERISA policy language, but it doesn't apply to a Medicare Advantage situation. Rawlings doesn't necessarily agree with that position. Now, the reason why these Medicare Advantage plans can be tricky is because of this double damage idea, particularly if it's hidden, if it's a hidden lien that you don't know exists, because you could contact Medicare through CMS, maybe using that Medicare portal, and find out that your client doesn't have any paid claims. Maybe you get a conditional payment letter that shows $0 and you're elated. But the problem is there's probably some other Medicare plan that has paid, like a Medicare Advantage plan. So if a Medicare or Medicare Advantage plan are not paid pursuant to the statute, then they can collect double damages against any entity. And this is any entity that's received payment from that primary plan. Any entity includes a beneficiary or a provider, a physician, an attorney, a private insurer. It's a long list of people, which means that your office certainly can have some liability on a Medicare Advantage plan if that Medicare Advantage plan chooses to pursue its recovery and seeks double damages. So this is why these types of liens shouldn't stay hidden. They should be uncovered and then addressed. So this particular regulation extends the private cause of action that Medicare has to these Medicare Advantage plans by clearly stating that Medicare Advantage organizations have the same rights to recover from any primary plan or entity or individual that the Secretary would have. This is also the language that is inside of that policy language of the Aetna plan that we looked at a couple slides ago. So there's definitely more legal history behind Medicare Advantage plans than what this shows, but this is just kind of the high level bits of it. So there is a CMS memorandum from 2011 that states that these Medicare Advantage plans have the same rights to recover as Medicare itself. Then in 2012, the Avandia case indicated that the Medicare Advantage plans could maintain a private cause of action to recover those conditional payments. 2016 had the Humana versus Paris Blank case, which allowed the Medicare Advantage plan to have the private cause of action against the plaintiff attorney that failed to reimburse the Medicare Advantage plan. Then Humana versus Western Heritage in 2016 allowed Humana to have a double damage claim against Western Heritage. Humana is often one of the insurance carriers that is driving their right to recover on these Medicare Advantage plans. This Western Heritage case is often a case that gets cited, particularly by Rawlings, as the reason why they don't have to reduce for attorney's fees, because in this case, the health plan, the Medicare Advantage plan, was able to get double damages in full and didn't have to do a procurement cost reduction. The argument on this side is that the reason why they didn't have to reduce for procurement cost is because the attorney and the primary plan was otherwise not cooperative, which would otherwise mean that if you are cooperative and you are trying to reimbursement, then at a minimum, they have to apply the procurement cost reduction. So it's just that ambiguity that allows them to swim in the gray space and argue that they don't have to reduce for procurement because in Western Heritage, they didn't have to and were entitled to double damages. So I want to turn to best practices to identify the hidden liens, known here as Medicare Advantage liens. So you certainly want to begin your investigation early to find out if one of these Medicare Advantage plans exist, if your client has one of these coverages or not. And a couple different ways that you can do it. Maybe you've already got these documents, maybe it's already part of your intake process, and that's excellent. But you always want to be asking for insurance cards, whether it's Medicare, Medicare Advantage, or ERISA or otherwise. So you certainly should be getting copies of the health insurance cards at your intake. You also want to make sure that you're updating this information throughout the life of the claim because people change insurance coverages. So if you bring in a case right now and that case goes on for 2 or 3 years, they could have 2 or 3 different health insurance coverages. And if they've treated the whole way through, there's that many liens that could be out there. Particularly concerning if they are Medicare eligible and are bouncing around from Medicare Advantage plan to Medicare Advantage plan. So how is it that you can obtain this information other than health insurance cards? Well, really, it's the medical records and the pharmacy records. If you're able to have copies of the bills, particularly if you're able to get copies of EOBs, like explanation of benefits that show who paid, there you could also get copies of actual bills from the providers that will indicate that they billed a Humana plan, and it might have a plan number, a member ID number. Those are certainly helpful documents to have to try to narrow things down, or at a minimum, kind of refresh your client's memory on it looks like you have a United plan here that paid for this medical expense, and then maybe they locate a card. You can also always call these providers and ask for more specific information, although that might be difficult to obtain if they want to keep it hidden. The other thing that is helpful is a MyMedicare.gov account. So this is definitely for the beneficiary themselves, but you can certainly work with your client to set up one of these accounts, and there is a report that is available, and this report will indicate all of the different health plans that your client has had since they've been on traditional Medicare. So this is in a number of situations for us, we've been provided this document, this report from plaintiff attorneys who have set it up in their office, and it's definitely helped us get to where we need to get to find the hidden lien. So it's definitely a document that can uncover the hidden lien. So if you are not familiar with MyMedicare.gov, go check it out. And if you have a willing cooperative client, get their information, set them up an account, and see all of the additional information that is available to you there. Here is a little snip of a section of the Medicare.gov report, just in case you've never seen it before. So you see there in yellow, the plans and coverage section. And then there's a number of other sections thereafter. So the top one is the Medicare Health and RX section. So here there is a Medicare prescription plan with Silver Script Choice. We've got a bit of a plan number there with the 064, and then we've got the effective date. So we at least know that it was December of 2018 and that it still appears to be current as of the time that this report was pulled. So that's certainly one way for you to be able to get to that RX plan, try to find them and put them on notice in that way. Primary insurance is where often an ERISA or a non-ERISA, some kind of other primary plan could be listed. Here, I know from this particular case that this person worked at this Adventist Health, so this is a self-funded plan that's listed here. Again, it's got some kind of policy number that can help get you to the right place, and then also effective dates, those coverage dates there on the final column. This is really just if you were to continue scrolling on the report, this happens to be like a second page of the same information. You see other insurance listed there, and California DHCS, so that is Medi-Cal, that is a Medicaid policy. There is not listed, there's no policy number that's listed there, but we again see December of 2020 is when this plan became effective. So now you can go down the Medicaid road to try to locate that statutory lien. And then we've also got Anthem that's listed here. 2018 to current, not sure what that is, but you certainly can follow up with your client to try to get some additional information. This is just a great way to kind of see a bigger picture kind of thing that at least gives you a jumping off place. It gives you some addresses. Sometimes those addresses don't get you where you need to go, but it's a starting off place, and it could often be more information than what you started with. So that's always a good thing. Now, in the past, these Medicare Advantage plans were definitely hidden, and the hope is that the PAID Act uncovers them and provides some assistance to plaintiff attorneys to be able to locate them if those other ways aren't helpful. If your client doesn't recall their health insurance, if you don't have good billing records, if the Medicare.Gov report doesn't have any information, or you don't have a cooperative client that allows you to access it, you still need to be locating these Medicare Advantage or RX claims because they've got this right to recover, and they have the ability to collect double damages if they're not reimbursed. So this PAID Act is the Provide Accurate Information Directly Act. The PAID Act was passed in 2020, and it was meant to help non-group health plans, responsible reporting entities better coordinate benefits by providing additional beneficiary enrollment information. So as much as this has been a difficult place for plaintiff attorneys, it's also a difficult place for defense attorneys and insurance carriers who are paying out these settlements. They have a requirement under Section 111 to report to Medicare that there's been a settlement. They are also on the hook for making sure that Medicare or the Medicare Advantage plans have been paid, but they were having difficulty locating the Medicare Advantage plans. So they pushed for this Provide Accurate Information Directly Act to provide this additional information. So just to make sure we're clear on definitions, the non-group health plans under Medicare, those are the liability insurers, the no-fault insurers, and the work comp entities who otherwise would be the primary payer. And then the RRE is the responsible reporting entity. And that's basically the party that's responsible for the payment to Medicare, for the person who, or the entity that made the settlement. So that's where the Section 111 reporting requirement comes from. So with this act, with the PAID Act, the RREs, the responsible reporting entities, will now also receive Part C and D enrollment information. So that's for the Medicare Advantage plans and for the Medicare RX prescription drug coverage plans. For the past 3 years, up to 12 instances, that would be if somebody jumped around all over the place with different plans. And so I imagine that wouldn't be that frequent that you would see 12 different plans in 3 years. But they'll also see the most recent dates that the person was on the Part A and B coverage, so that they had the traditional Medicare. So how is the PAID Act going to help? I mean, hopefully it really does uncover these hidden liens, because currently the Medicare portal only says whether or not someone has traditional Medicare coverage, particularly whether or not there are conditional payments that have been made since the date of loss that has been reported. If your person no longer has traditional Medicare, you're not going to see anything come back from the Medicare portal. It doesn't give any insight on the Part C Medicare Advantage plans or the Part D RX plans. So with this new process, with the PAID Act, the defense, the responsible reporting entities should be able to uncover these Part C and D plans, and then hopefully relay that information over to you as plaintiff counsel so that you can get a head start on getting them on notice, getting their claim summaries, auditing the claim summaries, fighting them for reduction, all of those things that you otherwise would be doing if you knew on the front end. So this is really, it's not really for plaintiff counsel, but the hope is that you'll now be able to be brought into the know through your interactions with defense, with the insurance carrier that's paying out that settlement, and then now these Medicare Advantage plans, these prescription plans that were otherwise just completely hidden and that maybe came out of the woodwork later, are now able to be dealt with on the front end. And that is one of the intended goals here of the PAID Act. And this concludes the webinar. Synergy is a settlement service company. We are talking about lien resolution right now, but we also have MSP compliance department that allows for all things Medicare to be uncovered and discovered. We've also got government benefit preservation trust referrals that are possible. We've got a attorney fee deferral program for your attorney fees that can save you some tax money. We also have settlement planning department for structured settlements and annuities to protect those settlement funds. And we do group projects as needed, as brought to us, although our primary is single event lien resolution. So thank you for joining us today. Here's our website address and the phone number to get to our customer support department. And we are more than willing to help you out with any Medicare Advantage plan that you might need resolving or any of those other lien types that we handle on a regular basis. So bring us your ERISA plans, your Medicaid plans that are asserting liens against the settlement, and we will battle them and try to make them go away as quickly as possible. But we are your partner and we are here to help. So we look forward to hearing from you. Thank you.